November 2022, the President of the Republic of Ghana relieved Mr. Charles Edubwahin of his position as Minister of State at the Ministry of Finance. Why? Because he had been caught in an investigative piece by Anas Arameyao Anas doing something that everybody decried. On Monday, the 20th of October, 2023, the OSP issued this statement. The OSP has issued an investigative report faulting Charles Edubwahin, a former Minister of State at the Ministry of Finance, for engaging in influence peddling or trading in influence. The OSP had more than sufficient basis to so conclude after forensic investigation and analysis of an investigative documentary titled Galamsey Economy, produced by Tiger Eye PI, a private investigation agency headed by the celebrated investigative journalist Anas Arameyao Anas. Influence peddling or trading in influence is a significant index of corruption worldwide. Mark that. Significant index of corruption worldwide. And it is deprecated under the United Nations Convention Against Corruption, UNCTAD. Though Ghana is a state party to the UNCTAD, the nation has yet to specifically prohibit influence peddling. Mark that. Specifically prohibit influence peddling or trading in influence as a criminal offense. Consequently, the OSP lacks the legal mandate to pursue prosecution in this matter. The OSP joins calls by civil society groups, particularly Occupy Ghana, on the passage of a Corrupt Practices Act and a Conduct of Public Officers Act. These legislative measures are essential for the establishment of a stronger legal framework and more effective mechanisms to combat and penalize corruption and corruption-related offenses. End. We'll be right back. This is the law. It's your legal light. It's your help law. It's our weekly legal clinic. You're welcome back. This is the law. It's your legal light. It's your help law. And this afternoon, we're going to help you understand and appreciate what the OSP, the Office of Special Prosecutor, means when it says that it cannot prosecute influence peddling, because that is what Charles Edubwahin was involved in. Many of you have read the report, and there are many who are angry, who are just unhappy with the Office of Special Prosecutor, with their outcome and the conclusions that they have reached. On the law, which is your legal light, your help law, we will deal with the facts and the law. We are privileged to be joined by Samuel Apiadako. He is Director, Strategy, Research and Communication, Office of the Special Prosecutor. Good afternoon and welcome to the law.
Thank you, Samson. Good afternoon.
Great. So, to begin with, we would like you to help us appreciate a bit what the OSP actually stands for. What's your mandate? What's your object? What do you do?
Thank you once again. The Office of the Special Prosecutor is an independent law enforcement agency and a prosecutorial office. What this means is that we investigate and we also prosecute. And we do so independent of the Attorney General of Ghana. And so our job is that we are a specialized agency set up to deal with specific offense, which is corruption and any other offense predicated upon corruption. I know that in Ghana, most crimes that are alleged to have been committed by politicians are tagged as corruption. But when we say corruption, it is a term of art, and for us, under our law, what constitutes corruption is clearly defined. And so it's not every matter that people hear that politicians are engaged in that may fall under our remit. But we do concede that Ghanaians largely say corruption is almost everything. So our job is simple. We are supposed to prevent the occurrence of corruption in Ghana. But if it does happen, then our mandate is that we are supposed to investigate it. And then when we investigate and we realize that there is a case for the person involved to answer, then we are supposed to send the case to court and prosecute. And we do all this independent of the Attorney General of Ghana. Some people have said that we have to go and get permission from the Attorney General. That's not true. We do all these independent of the Attorney General. And then we are also mandated to take profit out of corruption. And so whatever you might have gained from corruption, be it property as in car, a house, or even physical money, we are supposed to recover that and bring it back to the state. We have to disgorge it back into the state. So when we talk about the Office of the Special Prosecutor, this is what we stand for, and this is the work we've been doing since it was set up.
So as your law provides in Section 2, you are to investigate, and then upon the investigation, you prosecute specific cases of alleged or suspected corruption-related offenses. And beyond that, you are also to recover the proceeds of corruption and corruption-related offenses.
Exactly.
But there's a final leg that in Section 2C, you are to take steps to prevent corruption.
Exactly. And taking steps to prevent corruption involves so many things. If you go to our legislative instrument, LI 2374, it lists several things that we are supposed to do in preventing corruption. One of them is what we have just done, which is the issuance of a report on the conduct of the former Minister of State at the Finance Ministry, Charles Aduboahene, which is issuing what we call detected acts of corruption. So we are supposed to issue that, and we are even supposed to publish names of people who are being appointed into positions in government who we believe, based on our evidence and research, shows that they are people who should not be appointed by virtue of them having committed corruption or one act of corruption or another. We are supposed to do what we call corruption risk assessment. As you know, the first special prosecutor did publish something on the Ejapa transaction. And we are also supposed to even do what we call change culture. Culture that tends to breed corruption, and enactment, procedures, manuals of agencies and public institutions that also tend to breed corruption. We are supposed to take steps to ensure that these things are all changed. So it's a lot of work. And then
when you refer to your legislative instrument, you're speaking about the Office of the Special Prosecutor Operations Regulation 2018, LI 2374, Section 31 to be specific, is on prevention of corruption. And it says that the office may receive, collect, and collate reports, documents, materials, complaints, allegations, information, and intelligence to undertake the following measures to prevent corruption. Analysis of the risk of corruption, and that's what you refer to. You have done one under Martin Amidu. Anti-corruption programs.
Educating people.
If I asked.
This is an anti-corruption program. Being on your show.
All right.
We've also been to some senior high schools to hold some clinic in conjunction with other civil society organizations like the GACC. So we've been on it, and we just don't do corruption activity physically. We also do that through the internet, through social media. And sometimes you realize that when the OSP is trying to explain to people some of the things that they do not want to do, you find a lot of people saying that, oh, go and prosecute. That's the job you have to do. But that tells us something, that people have not really understood the fourfold mandate of the office. But also maybe it has to do with how it came to being. A lot of people, the expectation is that the OSP must be putting people in jail. But that is not the only job of the OSP.
And when he says the fourfold mandate, remember when we started, he spoke about their mandate under Section 2 of the Act, which is investigate, prosecute, recover, and prevent corruption, fourfold. And I continue to read, after saying you should conduct anti-corruption programs, it says anti-corruption assessment of legislation and draft legislation, provision of information in relation to persons applying for or holding position in the ministries, departments, and agencies which you spoke about.
Yes.
So you can literally determine that somebody cannot be a minister.
I'm not sure that we can determine, but I think that we are supposed to provide the information based on our research and based on our investigation and say that this person is not fit for office, and so do not appoint this person into office. But it's up to the appointer.
Must you be invited to do this, or you do it on your own?
We do everything on our own. We do not need even referrals from anyone. Our act took into consideration the limitations of the existing anti-corruption institution and decided that the OSP should be able to act on its own even without a referral or a complaint.
Because this provision says you may receive,
yes,
collect, and collate reports, documents, materials, complaints, allegations, information, and intelligence to undertake the following activities.
Yes.
Okay. It also says that you do provision of information to the Public Services Commission, and other legal entities.
Yes.
Education and information of the public.
Yes.
And then publicizing detected acts of corruption and other corruption measures provided by law.
Yes.
And you say the report you have issued on Charles Dubois falls under publishing detected acts of corruption.
Exactly. Yes. We call that special reports. But Samson, we just don't end there. If you go to 31.2, this is very important, and this is what we did when we did an investigation into the LaBianca and Customs case, where it says that the office shall identify the causes that advance corruption to facilitate the prevention of the corruption, including deficiencies in regulatory enactment, regulations or procedures, deficiencies in administration of instruction, including lack of internal control measures. And so you go on and on and on. And we are happy that when our preliminary investigation into the LaBianca and Customs, the GRA has also subsequently complied with the directive of coming up with a comprehensive procedure within which to ensure that corruption do not happen as it did in the past.
Right. Now we get to a very important and the purpose for our discussion this afternoon. This is the Law, It's Your Legal Lights. It is your help law, seeking to educate you about the business of the OSP that was set up by the state specifically to help prosecute, investigate, prosecute, recover, and prevent corruption in a manner that the Attorney General cannot do, because the Attorney General may find themselves in a conflict of interest situation because they are political appointees. They sit in cabinet with their friends and their political friends, so to speak. Right. So if what you have published on a Dubois forms part of a publication over detected acts of corruption, what is the use to the Ghanaian public if all you will do is investigate and tell us the person has done some wrong, but we cannot prosecute?
Thank you very much. It's very useful. It's very useful because not every conduct has been prohibited in this country. That's the first thing that a lot of people have to understand. It's not everything that you find offensive that may have been prohibited. And when we say prohibited, it means that there should be a specific law that says that what the conduct that the person is engaging is unlawful.
The Constitution says nothing is crime unless that thing has been defined and the penalty provided for it in law.
Exactly.
Okay.
For instance, I mean, you may find sleeping with your uncle offensive, but that will not be incest. But if you sit down, you might think that, whoa, someone has slept with the uncle. And we know incest to be that if you sleep with your daughter, your grandmother, and blah, blah, it amounts to incest. So why is this not incest? But in reality, that particular conduct has not been criminalized. What the OSP has done is to issue a report that says that we have investigated and gone into the conduct of a former minister of state. We have interviewed the journalists that did the investigation. We have also interviewed and interrogated the former minister. We have looked at all the laws that the OSP has been empowered to use. Remember, I said that it's not every law that the OSP can use to prosecute, except those that have been clearly been given to the OSP to prosecute under Act 959. And we came to the conclusion that indeed the minister has engaged in a conduct that is not appropriate, that is reckless, that if it had happened in any other jurisdiction would have landed him in jail. And that offense, we say, is what we call influence peddling. Now, the reason why we say it's influence peddling is very simple. It's because we've had the benefit of watching the raw tape, as we call it. We've had the benefit of interrogating the subjects in question. And we've also had the benefit of looking at all the laws before us. And we've come to the conclusion that, yes, the conduct is reprehensible. As you've noted, many Ghanaians have looked at it. And if you will recall, when this video even came up, a lot of Ghanaians had some reservations and said that they wish it had been more and that there could have been more that the Tiger IPI could have done. And we have assessed it and we've come to the conclusion that what he has committed would be offense in many other jurisdictions. But currently, as we speak, we do not have a particular law that we can use to succeed in a court of law. So we are saying two things. We have looked at the evidence and the facts, and we do not think that the evidence and the facts, as at this material moment, could sustain a charge in court. Now, the decision is very simple. When you have such a situation, would you want to go to court and say, because Ghanaians might raise issues that you must necessarily find something to charge him with, and you cannot find something to charge him with, so you must expend the taxpayers' money and go to court in a case that you do not believe in, one, in a case that you know that you will not be successful. Remember that the special prosecutor is to do justice. He's supposed to be fair. He's supposed to prosecute and not to persecute. So what he has to do is to look at everything and say that, do we spend state resources and go to court in a case that we do not believe in, we do not think that we have sufficient evidence, and we also do not think that there's a direct law that we can use to be able to prosecute such a person? Or do we issue a statement and say that we have found the minister to be liable for these things, and that these things that have happened, it's time that Ghanaians come together, put pressure on their government so that we can formulate a comprehensive corruption law. Samson, as we sit here, we do not have a comprehensive corruption law. We do not have a Corrupt Practices Act. In fact, some people have talked about gift. Do you know that as we speak now, Ghana does not have a law on gift? If you go to the UK, for instance, there's a ministerial code. The ministerial code says that a minister cannot take a gift beyond £140. So if you find a minister accepting a gift of, say, $40,000 US, and you have a law that says a minister cannot take a gift beyond a certain amount, it's so easy for your prosecutor to take this matter to court and prosecute. But when you live in a country where you do not have such a thing, we live in a country we don't even have what we call the reverse burden of proof. Corruption is one of the most difficult crimes to investigate and prosecute. And so the world over, and if you look at the United Nations Convention Against Corruption, it has provided that nations should try as much as possible and inculcate into their law reverse burden of proof so that the person who has been found to have committed something is the one supposed to prove to the prosecutor how he acquired those wealth or how he came by.
We are a common law country. We are not a civil law country. In civil law countries, the judges take proactive part in the prosecution of a case. And the reverse that you're talking about is what happens. You allege, but once I allege a crime against you, it is your duty to prove your innocence.
Yes, but your duty to prove
in the common law country,
yes,
he that is alleging has the burden to prove.
But I'm saying that it has changed. If you go to Kenya, for instance, they have reverse burden of proof, but they are Commonwealth jurisdiction. If you go to United States, Commonwealth, they have reverse burden of proof. The same thing in the United States and so many other countries.
So if
but we do not have it.
If a minister or a public officer accepts a gift, is it not possible to not just look at it as a gift, to be able to determine that it is an act of corruption, it's either bribery or something of the sort?
It's very simple. When does a gift become a bribe? When is a bribe a gift? It's very simple. It's a bribe when it's been given to the minister and it's supposed to influence the minister to do something. It will amount to a bribe. So the facts and the circumstances will determine when a gift becomes a bribe or when a bribe becomes a gift. So I don't think it's in doubt. But I'm also bringing up the issues that we are quite limited in so many things. And so when the OSP publishes such a report and makes recommendation, then the view is that as a nation, we should come together, look at it, and start amending and looking at how best we can come up with a very comprehensive legislation that could ensure that those loopholes and those gaps are clearly net. Other than that, 2 years to come, 10 years to come, we may end up talking about the same thing and not having made any progress.
So we'll go to the specific issue. But what do you say when you are pointed to Section 252 of Ghana's Criminal Offences Act, which says, 252, it says, 1, a person who accepts, we are putting it up so you can also follow us more meaningfully. A person who accepts or agrees or offers to accept, a person who accepts or agrees, so it's either you are accepting, you are agreeing to accept, or offers to accept a valuable consideration, money or anything of some value, under pretense or color of having unduly influenced or agreeing or being able to influence any other person in respect of functions as a public officer or juror commits a misdemeanor. You were talking about accepting gifts and so on.
Yes.
Is it not possible to use this provision to take care of a situation like that?
Well, it's possible, Samson. It's possible to do that. And here I will give an example. You know, in the UK, they have what they call the Bribery Act. And they do not have what we call a direct influence peddling legislation. But they've said that they're able to use their Bribery Act in instances where someone a politician abuses the office for personal gain. Now, when you look at 252, and I know that we are not here to teach law or to even attempt to teach anybody, but
it's a platform for education of the public. So
yes,
we're actually teaching the law.
Yes, but I also think that lawyers may not agree on one issue. They may have different perspectives on it. Now, if you look at 252, the heading, as you read, is accepting or giving bribe to influence public officer. So the ingredients are quite clear. 1, you either accept or you agree, or 3, you offer to accept. That's the first part. Valuable consideration, which is the bribe. So you agree or you accept a bribe, or you agree to accept a bribe, or you offer to accept a bribe. Then let's go to the third one, which says context. It said that you are doing that under the pretext that you have unduly influenced a public officer. That's the first one. You have unduly influenced, under the pretext that you have unduly influenced. Or you are agreeing to influence. And the third,
you are able to influence.
And the third one, you are able to influence another person. These are what this means.
And you are influencing them in respect of their functions
exactly,
as a public officer.
As public officers.
Right.
So the question you ask yourself is that, putting together, and like I said, if we had time, we should play back the video for a lot of people to watch. Then look at it and tell us which of them fits into this. We've heard a lot, and as you said, I don't think it's even true that many Ghanaians are not in agreement with the OSP. I think that if you take your time and you go through it very well, and you are not looking at it through one, a political lens, or two, you are not looking at it as another lawyer believing that you could have still gone ahead under this provision. And that one will come to an issue of policy, whether you think you can be successful or not. The special prosecutor has had a look at everything and said that this will not apply because where in the video that we watch, especially the raw footage, do you find the former minister accepting to go and influence someone, or accepting or agreeing to go and influence someone?
I'm going to read something to you, then on the basis of that, we'll continue. On your own statement, point 3.3.
Yes.
The complaint alleged that through its sting operations, Tiger IPI audiovisually recorded Mr. Edubwahing in the act of his commission of corruption and corruption-related offenses. So we are being told the story of what transpired in the video. And we are sharing that with you on the screen. Corruption and corruption-related offenses. The complaint stated that undercover agents of Tiger IPI posing as businessmen who were interested in investing in Ghana met with Mr. Edubwahing and tabled their investment plans and proposals to him. The complaint alleged that, sensing an opportunity to cash in on his position as a Deputy Minister of Finance, Mr. Edubwahing demanded 20% of the value of the proposed initial investment, or 10% upfront payment of the value of the proposed initial investment, and post-investment sharing of the proceeds of the investment. The complaint also alleged that Mr. Edubwahing offered to introduce the undercover agents to the President and the Vice President in aid of establishing them as very influential persons in Ghana. It was alleged that this offer was premised on Mr. Edubwahing's stated close ties to the President, akin to an uncle and a nephew relationship, and his political connection to the Vice President. Last one. The complaint further alleged that Mr. Edubwahing demanded $200,000 United States dollars to be given to the Vice President for the purpose of facilitating a meeting to be set up by Mr. Edubwahing between the Vice President and the undercover agents. You are saying that what the law here requires, the ingredients, the activities required here, are not satisfied?
Not at all. They are not satisfied.
Okay, explain to us.
Yes. So if you watch carefully, and we have tried so hard to move away from this position where you appear as if you are a lawyer even for Charles Edubwahing. But we need to explain why we think that it's not on all fours with 252. 252 says that you must have accepted. If you watch the raw footage, what happened was that...
It doesn't say you must have accepted.
I'm coming. Accept.
It doesn't end there.
Yes, I know, accept.
Accept.
So we are taking it one by one.
That
yes.
you are able to.
We are taking it one by one.
Okay.
So
right.
we are taking one by one. So let's take accept. If you watch the video, this is what transpired. Now, the undercover agents asked Mr. Dubois that those who do this job, how much would they take? And then he said, no, if you can come up with something. Then they kept pushing him. And then he said, 20% would be good. So he was requested to give a percentage.
He did give.
And he did give a percentage. And that's where he said he was surprised that they didn't contest it. And remember what he said. He said that those who do it, of course, you are going to lead it. What percentage would they take? So he was requested to give a percentage. When you look at the first ingredient, which is accept, agree, or offer to accept, depending on how you look at it and the nuances, you might say, okay, it may satisfy because whether it was a request to him or not, at the end of the day, he did give a percentage. But the context is what matters. So first of all, you must prove there is bribery. And the second part is that, where in the video did Mr. Dubois say that he has unduly influenced, one, or he is able to influence, two, or that he is able to influence others? And who are the others? Did he say that he is able to go and influence the president on record? Something, let's not forget that this is a criminal trial.
When you say
yes,
that what he did is influence peddling, what do you mean?
Yes. So when we say what he did is influence peddling, it's a very simple thing. What is influence peddling? Influence peddling simply means that one is abusing the position that he or she enjoys in the decision-making process that for a third party by that person.
So I come to you.
Yes.
And I say, sir, I know this man in the public office. I know you are interested in this kind of business. I can assist, get him to help you to establish. And in this case, they were interested in establishing a banking or a financial institution. So I'll be like your go-to person and help you get through to him to help you do all of this. And do it in the manner that perhaps the laws of the country don't allow.
Yes.
And I'm getting paid for it. Correct? I'm a public officer. I'm involved in influence peddling. Am I?
Samson, let's look at it this way. And first of all, let's deal with 252 because a lot of people have brought 252 and I want us to deal with 252. If you agree with me that the first part of the offense, which is that you must have accepted a valuable consideration by either agreeing, accepting, or offering to accept. We are saying that if you look at it in that way, you might see bits and pieces of that. But
is it bits and pieces or
yes,
actually that is what transpires?
You might see bits and pieces depending on how you situate the facts.
He says, we'll take
because I said that, that's why I said that the meetings were in different, if you watch the raw footage, the meeting are in different categories. The first time is that I've come to you and then I want to establish a bank in Ghana. Then I ask you, what's the procedure? Then you give me all the procedure. Then I go into a second meeting with you and say that, well, I have $500,000 that I want to invest into the country. I want to have a footprint in the country. Who are the people that I can see and blah, 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 blah? How can you help me?
I'm a minister. I know the vice president. I know the president. I know the vice president. We can use him. He's the go-to person. He's the man in charge of this.
That is why we are saying that influence peddling is the best, because you see, he's exacting his position for undue advantage. But when you want to use 252, you must prove these other ingredients that we have listed here.
Which other ingredients?
That you have unduly influenced, as you read. Now, my question is that, do you have any facts to support that he has unduly influenced? The second part is
it your case that because the planned investment, as in setting up the bank, has not happened,
Not necessarily. And we can use even the Nyantechi case to distinguish. If you recall the Nyantechi case, when they had talked about every other thing, you remember Nyantechi had even said that's why the famous that the president was in his pockets and blah, blah, blah. You realize that after the discussion, they gave him $100,000. Now, when they gave him $100,000, Mr. Nyantechi was supposed to go somewhere else, but he missed his flight and instantly used the time to draft a contract, handwritten contract, and gave it back to me and said, type it and send it back to me. So you realize that the Nyantechi case is a bit different from this other case.
What you mean is that in the Nyantechi case, they had moved further, they sort of consummated the oral agreements or discussion.
No, I mean, you can find more facts and evidence to support a charge that you want to use. But in this instance, I know some people say inchoate offense, inchoate. I'm like, of course, and some people even talk about it's like preparation. I'm like, how do you compare this with preparation? The point we are making is that you must satisfy these other three conditions.
Yes.
And I'm
what
asking
these
those
other
questions.
Three conditions.
Let's go through it.
Says, either you have accepted.
You are still on the first one.
Yes.
No. Let's go back to the second.
I need my viewers to follow that.
All right.
Either you have accepted, agreed to accept, or agreed to offer to accept.
Yes.
You offer to accept. You have not accepted.
Yes.
Whatever is being given, whether it's money or it's some promise of sort, of a benefit.
Yes.
Under the pretense that you have unduly influenced something.
One.
Or that you are able to influence that thing.
Two.
Any other, or of agreeing or being able to influence. So either you agree to influence, or you are able to influence any other person in respect of the functions of a public officer or a juror.
So let's take the vice president. So Adubuahin has agreed or has accepted or has offered to accept money.
Correct.
And that money, he's saying that, one, he has been able to influence the vice president to do their bidding.
So let's say that part does not apply.
Yes. Two,
it's not have
or that he is agreeing to go and influence the vice president to do their bidding.
That's where we are. Or that he's able
to do it.
That's where we are, isn't it?
Where did he give such promise? You see, we have said that we are dealing with a criminal trial here, and people don't get it. It's a criminal trial. You must prove beyond reasonable doubt. At the OSP, we have a policy. And those who do not know, at the OSP, the special prosecutor has a policy. It might be too high for some people, but internally we know what the policy is. That the special prosecutor will not go to court unless he is satisfied that we have sufficient evidence to ground a charge and that we will be successful. Other than that, his view is that we will not spend the taxpayers' money on such venture. I understand that some lawyers say that, I heard some comments, some lawyers say that, you should have stretched Dubois small by just sending me to court, and 3 years he'll be moving up and down in court. I'm like, really? If that is done to you as a citizen, will you be happy that even though the prosecutor is not satisfied that he has enough grounds, and that he should be taking you to court? And I said, we are all coming from private practice. Samson, I'm just coming. When we decry police officers, when they take on our clients, when there is no clear case against them, that will be persecution. And I'll give an example. When Mr. Kisejap, my boss, took over in 2021, there was a trial involving Mahama Yariga. He came into office, looked at the evidence and the facts, went through over and over and said that the Republic doesn't really have a case against him. And so he filed a nolle prosequi and discontinued the trial. That is justice. He is setting the precedent to say that if the OSP does not have a case against a person,
that's appreciated, but let's get back.
The OSP will not go on.
That's appreciated, but let's get back. In the context of influence peddling, which ingredients you may see bits of it in the face of this provision of the Criminal Offences Act? You are not the court. Why do you want to have a cast in iron case and say, until I have that, I won't go to the court. So are you exactly right when you say that influence peddling is not prohibited by our law, when from all that we have read around just this one provision, it looks like one can be caught for influence peddling?
I understand, but 252 is not on influence peddling. You see, ONCAC is as young as 2004. This provision is very old. And I've even said that even when you go to the UK and so many other countries, they are reluctant or they are failing to come up with a law on influence peddling because they said that it's so difficult to come up with what kind of influence is legitimate and which one is not illegitimate. The special prosecutor has come up with a suggestion. His argument is that it's time that we criminalize this. Now, there's a professor in Cambridge. He recently did a survey in Ghana, in the tertiary universities, and came up. And so when this report was issued, he put up a comment on Facebook. This is called Justice Tembe. He had done a research and came up with this one and said that most tertiary students were engaged in influence peddling. And it's a serious matter that if Ghana does not look at it, these people will grow up to become politicians and we will have trouble on our hands. My point is that we must look at the bigger picture. The bigger picture being that it's time that we look at our corruption laws. Right. It's time that we enact Corrupt Practices Act. It is time that we enact a law on the conduct of public officers so that we can have a clear provision
whilst we are working at that, and clearly the advocacy has been very strong in that regard. Can we also look at this provision of the law that's been pointed to you?
179.
Section 247. Yes, Section 247 of the Criminal.
That's extortion.
Offenses. Yes, Section 247 of the Criminal Offences Act. And the specific provision, and we're sharing that with you so you can follow us, is on explanation as to extortion. And it says, a public officer commits extortion who, under color of office, demands or obtains from a person, whether for public purposes or for personal gain, or for any other person, money or valuable consideration, which the public officer knows is not lawfully authorized, or at a time at which the public officer knows is not lawfully authorized to demand or to obtain that money or valuable consideration. What do you say about this one too?
Well, this is the least of them that we could have used. We have looked at all these provisions, but let me begin with the technical problem of 247. Please go to section 79 of Act 959, which is
your law.
Which is our law, Office of the Special Prosecutor Law.
That is definition?
Yes, definition for corruption.
Okay.
I feel like we are in law school, but
that's the purpose of this place. So,
okay.
Section 79.
Yes, please. And we restrict ourselves to only A, the definition for corruption. So we look at 42, page 42.
Okay. The definition of corruption, it says corruption and corruption-related offenses means offense under sections 146, 151, 179C, 239, 252, which we have just discussed, 253, 254, 256, 258, and 260 of the Criminal Offences Act, 1960, Act 29.
Please, do you find any provision on 247?
No.
Yes, but you find 151. So let's go to Act 29, 151.
Right. So the law prescribes that if you have to handle corruption cases, and when it says corruption, and you have to use our Criminal Offences Act, it tells you specific provisions on which you can prosecute.
Exactly.
There are some that you cannot prosecute on.
Yes.
So the section 247 I referred you to does not, you have no power over it.
Yes.
Because the law doesn't give you power over it.
But
however, the law gives you power over 252, which I mentioned earlier.
Yes. But this is even a mistake. Because if you go to 151, they mentioned 151.
That's what it is. So we cannot be saying it's a mistake. So you say I should go to section
151.
151.
Yeah, because that's what our law says.
Okay. Section 151 of the Criminal Offences Act, 151, 152, 151 is here. 151 is on extortion.
Yes.
It says a person who extorts property from any other person by means of threat commits a second-degree felony.
So that you see, that's what we said. It must have been a mistake by the lawmaker. The lawmaker may have been referring to 247, but then they provided 151. Now, if you are to go to court, and that's why he said
because the law cannot give you power over 151 and then take the power away from you over 247.
Yes.
Okay.
So it must have been a mistake.
Because 247 is an explanation of 151.
Exactly.
So that's where you think that was a mistake.
We think it's a mistake. But I know that if we were to go to court on this, you being a defense attorney will come and knock us down with this one. Right. But beside that, let's look at it. Even if we had 247, whether 247 will be applicable. For me, I do not see anywhere 247 will be applicable, even if the OSP had the power to prosecute under 247. Looking at the facts and the evidence that we have seen and have come to a conclusion on. Because when we talk about extortion, there must have been an involuntary pattern of something from you by a public officer or someone demanding it from you. My question is, where did Charles Dubois demand something from the sheikh? Everything was more like a gift. You take this for shopping, you take that for this, you take that for that. I agree. That's why I said that you might find patches of most of our laws in it, but they are not conclusive enough for us to be able to go to court and ground a charge. And that's why we're saying that we are not going to expend public resources on it unless you want to do what we call persecution. But the OSP has not been set up to persecute people. The OSP has been set up to prosecute people and to do justice. And that is exactly what the special prosecutor has been doing since he assumed office in August 2021, Samson. There's several cases that we have in court is because the OSP believes in those cases, and we know that we have sufficient evidence to ground a charge. Other than that, we would have got into it. Now, I'll tell you something. Some people say that the SP must be very enterprising and not be in a shelf and think that if he doesn't push, he will have things on a silver platter.
So let me do this. We'll open our phone lines now. Sorry, we are opening it late. This is the law. It's your legal light. It is your health law. And we are engaging the Office of Special Prosecutors, Director of Strategy, and also communications to help us appreciate why Charles Dubois, they claim, has committed acts of
akin to corruption,
influence peddling, acts that actually ground corruption. But they say in Ghana there's no law to prosecute. But many share the view that the section 252 that we just read a while ago is a potent tool that they could have used. You can call, and remember, on this program, we don't do politics. If you have any question to ask, we don't use insulting language or anything of the sort. So if you call, just ask your question in a very simple manner. If you want to make a contribution, very quick, and then he will respond to you.
But some before the calls start coming, I was saying that the SP is very enterprising and adventurous because you have the Sir John case where you look at our laws, and if you are not careful and you don't read our laws well, you might think that we do not have a provision on non-conviction based forfeiture. That means if someone dies before we get to know that the person has engaged in corruption, it means that the family of that person takes away all those property that the person may have used corrupt means to achieve. The SP said no, that OSP actually has the law to deal with this. Okay. And yet when we went to court, the court disagreed with us. So it's not that we have not been
Salfu is calling us from WA, but we've got a lot of messages. They seem to disagree with you under Section 252.
And that's the beauty of
either
law.
he has accepted, he is agreeing to, or that he is able to influence, and they see all of that in the video, and yet you say you can't prosecute. Hello, Salifu, you are calling us from where? Let's hear
It's because they're not looking at the second part of that.
Salifu, quickly, let's hear you.
Yeah, thank you, Samson. My question is on the other two provisions. Is the OSP guy telling us that you should be very sure, or are you a judge? Are they playing a judge role? Because you are, when a lawyer is going to court, you are going to court with issues for the judge to determine the case. So you sit in your office and determine when the other two clauses you read indicate that he says he's able to influence the vice president. He's going to introduce them to the vice president and all that. So they are sitting in their office, acting like judges.
Okay, thank you.
But Sam, let's correct him because he has imported facts.
So this particular provision,
has imported
let's
facts.
take this particular provision off, and let's keep to the 252. Thank you. Keep the.
But Sam, so let's correct him. He has imported facts and said that Mr. Dubois said he's going to influence. It's not part of the facts. And we have to be careful.
He demonstrated that he's capable of.
He's not demonstrated anything that he's capable of. He only talked about his relationship with them.
What is the purpose of talking about that?
When you talk about because what was the purpose of the sheikh asking him for that? The sheikh said that he wants to be able to meet them. And he says, yes, you can meet these people. You can meet these people. I know them. You can meet these people. It doesn't mean that he has demonstrated that he is going to influence them. Let's not be important facts. Other than that, you might think that somebody is doing a cover-up when, in actual sense,
Sasu,
we are just
you are calling us from
law.
Bantama. Let's hear you, Sasu. Hello, Sasu. We lost Sasu. What happened? Why did we lose Sasu?
Maybe he wants me to finish the point. So when you import the facts, like many other, even lawyers have been importing facts into what it is. Meanwhile, they've not even seen the raw footage.
Why?
But the
raw
importing
footage was shown to the whole world.
That's not the raw footage.
I said the raw footage. The video is.
Yeah, the video. But I'm just saying that even the video that you watch, there is nowhere it says that I'm going to influence. And we have to be very careful. I know that, yes, it's juicy. He has done unthinkable things, and that's why we have indicted him. That's why when I find pro papers going ahead to say he has been cleared, I wonder, I'm sitting down, I'm like, where in this report has he been cleared? A former minister of state has been indicted by the office of the special prosecutor that he has engaged in influence peddling, and you are saying that he has been cleared.
He just said that. Are you a court? What do you mean by you have indicted the person and you have not taken?
Of course, the office, the special prosecutor is the equivalent of a court.
Let's hear you. You are calling from Inkaria, is it? Let's hear you.
Hello.
Go ahead, Solomon.
Good afternoon, Samson.
Let's hear you.
Yeah, I'm very interested in this program. I was just reading the United Nations on United Nations Convention Against Corruption, and what they describe, influence peddling is part of corruption. That's why I've just read it.
That's right. Thank you very much. And you are right about that. He's right, is he not?
He is very right. And that's why we are saying that it's time to domesticate. Remember, people forget that Article 18 of UNCAC has to be domesticated, just like Article 36 has been domesticated. Article 36 is why we have the Office of the Special Prosecutor. Because Article 36 says that every state should set up a specialized independent body.
Demanded, to the extent that what he did, you find it to be improper?
Of course.
Is that not what the UNCAC, particularly, Article 17, is clear about? It's
UNCAC on Article 17 is about misappropriation and other things. It's not on...
sorry, who is on the line? Sasu, you are back. Go ahead.
Yeah, something.
Yes, go ahead. Very quick.
Okay. Yeah, I am not a lawyer, but listen to what my friend,
his name is Apia Adako.
Yes, Adako is saying. He was saying that there is no comprehensive law in Ghana to prosecute. Yes, to prosecute
influence peddling,
no corruption.
Yes,
generally.
But what I'm saying is that he made mention of other countries having that same law. Can't we adopt from other countries to be able to deal with this issue?
Okay, so that's the point they are making. That's the point they are making.
Well, so to help now, we are clarifying. We are saying that influence peddling is a serious offense in other countries, except that in Ghana we have not domesticated it. So when some people hear influence peddling, they think that it's a slap in the back or a tap on the head. It's a very serious offense that will end you in jail if you are found liable or guilty. So when people hear influence peddling, they are thinking in their heads, okay, it's nothing so serious. Please, influence peddling is a very serious offense to be indicted with. And then some said that we have constituted ourselves into a court. No, we are an investigative body, and we are supposed to make our findings known to Ghanaians. Again, we are just not an investigative body. We are also prosecutors. And so a prosecutor must satisfy him or herself that there is enough or sufficient basis to go to court. Remember, the special prosecutor is the equivalent of a justice of the Court of Appeal, and a very seasoned lawyer at that. So he's supposed to satisfy himself before he goes to court.
And I'm getting a lot of messages from lawyers actually, and they believe that the Section 252
yes,
of the Criminal Offences Act
can be used.
Is a good law on influence peddling. So you are not right to say that we don't have a law on influence peddling. And in fact, I think about 2-3 of them insist that put the person in court and let him be the one to defend himself otherwise.
Exactly what we said. Remember, we are what? The special prosecutor is an officer of the court. He's supposed to help the court. You're not supposed to send cases to court when you know that it's not strong, it cannot grant a conviction. Remember, we are also spending state resources. I mean, we have trials in Kumasi, in Tamale and Co. It's a lot of money to go through trial. It's a lot of money, a lot of time. And so we have to use our resources judicially. We are not supposed to just go ahead and prosecute somebody and see whether the person will be put in jail. And that's why I said that they are defense lawyers. Would they be happy if...
It was clear that he was seeking to use his office for private gain.
No doubt. And this report will forever follow him. This report will
one's
forever
office
follow
for
him.
private gain is corruption.
He has not
That's
used...
the crime.
Where has he used his private gain? When you say you have used your office for private gain, look at the PPA case.
Okay.
Where we have said that he was selling contracts and making money.
Time runs
I know,
fast.
I know. I wish we had more time.
Samuel
And I wish
Dako, Director, Strategy, Research and Communication, Office of the Special Prosecutor, on the question why the OSP says it can't prosecute on influence peddling, which is actually what amounts to corruption. And we have gotten the explanations. We will bring you another side that believes that this is the OSP running away from its job.
But can we also say that we at the OSP will welcome every divergent
All right,
opinion.
thank you very much. This has been The Law. It is your legal light. It is your help law.